My name is John Gailus. I'm a lawyer with Devlin Gailus Watson. We're a law firm in Victoria, BC. And I've been working with First Nations and First Nations businesses for the past 20 odd years and assisting them with their economic development initiatives. Well, property taxes are one of the really important tools that First Nations have available to them, obviously to generate income on the reserve. But in order to do so, you also need to have economic development. So as a general rule, First Nations are not taxing their own members on their interests on reserve. So they're going to need to have leases from third parties as well as utilities and the like. There is a relatively new piece of legislation called the First Nations Fiscal Management Act, which is available to First Nations to actually leverage their property tax revenues to fund infrastructure on reserve. Under this new act, First Nations that can pool their tax revenues, and not just simply their tax revenues, they can also use lease revenues and the like. And it goes into a pooled investment through an entity called the First Nations Financial Management Board, or First Nations Finance Authority, and they operate a lot like a municipal finance authority does, and they go out and seek lenders to finance infrastructure. One of the problems with working on reserve is a lot of lenders are not willing to lend, or those that do charge really high rates of interest, just given the uniqueness of reserve land and not being able to seize it. So there many First Nations, I think there's 99 First Nations right now in Canada, have qualified for this program, although I don't think that they're all operational, meaning that they're all at various different stages in the process, but they can, they have a much easier way to access, infrastructure for roads, sewer, water, schools, that sort of thing. West Bank is a really good example. They're located just west of Kelowna, here in British Columbia, and they were one of the first First Nations to really take advantage of the amendments to the Indian Act in 1985, which allowed for First Nations to tax on reserve. And they've got a number of commercial developments that they get property taxes for, and have reinvested in their community. Kamloops is another example of Kamloops First Nation is basically in the city of Kamloops, so they've been able to leverage their property taxes as well. And Siksika First Nation in Alberta is another example. I know that they're doing some interesting things with their property taxes. Well, that's a complicated question. One of the other pieces of legislation that's out there is the First Nations Land Management Act. Now, this is a piece of legislation that the Liberal government passed in 1999, which allows First Nations to opt out of various sections of the Indian Act. One of the challenges for First Nations is that when they want to do economic development, they need the approval of the Minister of Indian Affairs, usually, if they want to do that. And there have been a lot of problems in terms of the timeliness of that. So many nations have taken advantage of this legislation, First Nations Land Management Act, to fulfill their economic development objectives. So they no longer have to deal with the minister, but the land still remains reserved land and still subject to many other sections of the Indian Act, including Section 87, which is the tax exemption, and Section 89, which is a section dealing with an exemption from seizure. So that's one of the tools that a lot of First Nations are using to move ahead. So there are these tools that successive governments have put in place to overcome many of the problems with the Indian Act. Well, there's a number of them. I mean, it is a unique situation. I mentioned Section 89 of the Indian Act being a section that lenders, it tends to scare off some lenders because you can't actually seize reserve land unless there's a lease in place. So if, say, for instance, if you wanted to develop a shopping center on the reserve, you'd have to get a lease from the minister, or if it was under First Nations Land Management Act from the band, that lease could be mortgaged, and a lender, if there was a default, a lender could come in and foreclose on that lease. They just can't, unlike off reserve, they can't come and take your home away. So that's one of the challenges. And then there's all kinds of other challenges. Band councils often change every 2 years under the Indian Act, so that can be challenging for third parties who are wanting to negotiate a lease on the reserve. There is a unique tax regime, so sometimes separate from property tax. I mentioned Section 87, but First Nations also have some immunity from taxation under the Income Tax Act. They're treated much like a municipality in that they don't pay any tax on their income. They're a local government, so properly structured, their businesses can avoid paying tax on their income. Well, I think it's part of that package. So, what's happening is First Nations are slowly but surely moving towards more towards managing their own affairs, getting out from under the Department of, I guess they call it Indigenous Affairs now, the federal department, and along with First Nations Land Management Act, the Fiscal Management Act, many First Nations are moving that way. It's still a long way to go, and managing your lands, managing your property taxes, investing in your own infrastructure rather than begging the federal government for your capital project. There's a number of First Nations, as we're aware, that are still out there that are waiting for water and sewer treatment plants. They've been in the queue for years, and the department only has a certain amount of money that they're prepared to put forward on these projects. So for First Nations to lease their land, tax it, and then pledge those revenues, through this First Nations fiscal management process, they can get the infrastructure in place a lot quicker than simply waiting for the department to come and approve their capital project.